Alright, this will be the People News. This video is actually going to be pretty long, so it's going to be part two of it as well. Alright, so this is not a substitute to the original content. Go check him out. He's got a bunch of great things on his catalog, okay? And it's 10th Amendment Center. Alright, so go. Don't sit there and wait for me. Go now. Alright, this is We the People News. Not attorney, not giving legal advice. Educational purposes only. Right? Alright. Never look straight forward. Always look around you to be able to protect yourself by any means necessary. Arm yourself with knowledge. Use that Second Amendment, people. Alright? Let's dig a little deep on the original intent of the Ninth Amendment. And when you use the 10th, you got to use the 9th. They're kind of carry on. And, even with the 10th Amendment, the attorneys use it for the state and never the people. So we need to start using the 10th Amendment as the people. Okay? Because, Jesus, the rights they violate. Pennsylvania versus Mims. Marbury versus Madison. They gave themselves kingship. Okay? And Hale versus Hinkle. Well, that one's okay, but it is what it is. The Terry shit. Right? Terry versus Ohio. That's the biggest crap violation of the Fourth Amendment. I don't want to dig any deeper. Let's check out the Ninth Amendment and what the original intent in history from what you guys call the Founding Fathers.
Thought it was the final lock. The Ninth Amendment. Most people have no clue what it says or does, or they just ignore it, or they get it totally wrong. It's not a grant of additional federal power. It's a firewall against it, a rule of construction meant to work in conjunction with its partner, the 10th Amendment, in support of federalism.
And this is the reason why the courts, and it's not hardly ever used by attorneys, because the courts don't want you to use it, because you got too much freedom in the Ninth Amendment. Okay? And this is the reason why they have a tendency to ignore it. But we're ignored because we're not throwing this in just about every single document, y'all. Never mind just only the Fourth Amendment. Violation of the Fourth Amendment, it's violation of the Ninth Amendment. Violation of the Fourth Amendment, it's violation of the 10th Amendment. Right? And since the violation of the Fourth Amendment, it's violation of the 8th Amendment. But they're just only sticking in these one particular subject matters when it needs to be spread out. Because if breaking one, it's breaking them all.
On this episode, the forgotten history behind the long ignored but incredibly important Ninth Amendment. But first of all, before getting to that, welcome and thank you for joining me here on the Path to Liberty. My name is Michael Bolden with the 10th Amendment Center, and this is the show for Wednesday, August 6th, 2025. Now, in order to understand the original meaning of the Ninth Amendment to the Constitution for these United States, we first need to understand the fundamental debate between Federalist and Anti-Federalist over whether or not to even include a Bill of Rights that happened during the ratification debates. The Federalist side saw it as a trap that would expand federal power. Not all of them. Here's James Madison, who said, this is in a letter to Thomas Jefferson. He later wrote the Ninth Amendment, Madison, but he was saying he was open to a Bill of Rights, in favor of it, with a caveat. He said, my own opinion has always been in favor of a Bill of Rights, provided it be so framed as not to imply powers not meant to be included in the enumeration. But many more on the Federalist side, well, they repeatedly warned that trying to list out some fundamental rights would actually create a scenario where eventually it would destroy liberty rather than protect it, because it would allow scheming politicians, which I guess is redundant, to expand centralized power. Here's James Iredell, who was one of the first associate justices on the Supreme Court. Here he is in the North Carolina ratifying convention. He said it would be not only useless, but dangerous to enumerate a number of rights which are not intended to be given up. Because, he said, it would be implying in the strongest manner that every right not included in the exception might be impaired by the government without usurpation, and it would be impossible to enumerate every one. Of course, we know that there's a vast reservoir of rights that aren't listed out anywhere. And Iredell explained that. He said, let anyone make what collection or enumeration of rights he pleases. I will immediately mention 20 or 30 more rights not contained in it. So you couldn't list out all the rights. That was a great concern. And this was pretty much the standard Federalist position, and was also argued in support of this position by some of the other big government guys like James Wilson or here Alexander Hamilton.
We're going to just pause there for a second, right? And this is what the statutory shit is, okay? They're trying to get every little bitty thing to violate your rights, right? And they make it so convoluted and under legalese that when you read it, you implied it into a direction that is not true. And it's in design that way to mislead you.
In Federalist number 84, for why declare that things shall not be done which there is no power to do, he wrote. Why, for instance, should it be said that the liberty of the press shall not be restrained when no power is given by which restrictions may be imposed? So the Federalist side is saying over and over and over, look, this is a document of delegated and reserved powers. If it's not delegated there in the first place, well, why should we add a restriction when they're not authorized to do it in the first place? But the Anti-Federalists, well, they weren't having it. And they saw two great threats in this scenario without a Bill of Rights, without specific limitations on federal power. First of all, one, Congress would try to exercise powers not given to them. They would claim additional power beyond the delegated powers in the Constitution. Threat number two, they would also twist the meaning of those powers which were enumerated in the Constitution and expand federal power that way as well, not just by exercising powers not specifically delegated, but also a construction of federal power that expands federal power.
Moreover, how are they doing it? Administrative statutory. All right, using Roman civil law tricks to misconstrue and mislead you.
Repeatedly in the ratification debates throughout the states in 1787 and 1788 primarily, they insisted on express declarations despite what the Federalist side was promising. Here's Federal Farmer in his fourth essay, October of 1787, who was directly criticizing James Wilson's position that a Bill of Rights was superfluous, unnecessary, even dangerous. And here's how he put it. The general presumption being that men who govern will in doubtful cases construe laws and constitutions most favorably for increasing their own powers. Students of history, students of human nature, they understand that people with power always end up trying to expand their power over time. Now, maybe not each individual person with power. Every now and then you find some rare unicorn who doesn't do that. But over time, if you're not really clear about those delegated and reserved powers, about what rights are off limits, well, sooner or later someone's going to find creative ways to just expand their power anyways. And Federal Farmer put it like this. All wise and prudent people in forming constitutions have drawn the line and carefully described the powers parted with and the powers reserved. The Anti-Federalist side, in state after state after state, repeatedly rejected the Federalist claim of rights being off limits to the federal government without expressly saying so in the document itself. In the Virginia Ratifying Convention, George Mason may have summed it up best. We wish only our rights to be secured. We must have such amendments as will secure the liberties and happiness of the people on a plain, simple construction, not on a doubtful ground. Now, even some of the most ardent Federalists, here we're back to Alexander Hamilton, even though they were denying that the Constitution would create a scenario that would authorize expansive interpretations or constructions of federal power, well, they still admitted that there needed to be limits, for example, on the interpretive methods of the judiciary. Here's how Hamilton put it. To avoid an arbitrary discretion in the courts, it is indispensable that they should be bound down by strict rules and precedents, which serve to define and point out their duty in every particular case that comes before them. But when the Constitution was being considered in the ratification debates, it had no such strict rules. And before it got amended, it had no rules of construction, or I guess we could call it interpretation, at all. And then starting in Massachusetts, then other states like New Hampshire, Virginia, New York, and others, they all made deals to vote in favor of ratification as long as they could include recommended amendments in their ratification document. For example, like this one in New York, that every power, jurisdiction, and right, which is not by the said Constitution clearly delegated to the Congress of the United States or the departments of the government thereof, remains to the people of the several states or to their respective state governments to whom they may have granted the same. And you'll notice that that sounds very similar to Article 2 of the Articles of Confederation, which was about delegated and reserved powers, a precursor to the 10th Amendment, delegated and reserved powers. But they also have something that's a bit of a precursor to the 9th. Not super straightforward, but it's definitely there. And interestingly enough, it's not even a separate paragraph. It's really the same sentence, only separated by a semicolon. They went further with this. And that those clauses in the said Constitution, which declare that Congress shall not have or exercise certain powers, think, for example, shall not be infringed, it was one that ended up in there. They do not imply that Congress is entitled to any powers not given by the said Constitution, but such clauses are to be construed either as exceptions to certain specified powers or as inserted merely for greater caution. And again, that first half of that declaration was really about delegated and reserved powers from the Articles of Confederation, a precursor to the 10th. Here's how Kurt Lash described it. The second half of New York's declaration reflects the concerns raised by both Federalists and Anti-Federalists regarding the potential dangers of construction in the Constitution. If you list about a bunch of rights, will it be construed that this is all that exists? Federalists, he writes, claim that a Bill of Rights might be construed to imply that the only limits to federal power were the express prohibitions contained in the Bill of Rights. The second provision prohibits this kind of implied expansion of federal power. Now, North Carolina took a very similar approach. Here's their first recommended amendment to the Constitution 1. Again, this is going to sound familiar. Again, they're always connected, this 10th Amendment, 9th Amendment thing, or vice versa. First, that each state in the Union shall, respectively, retain every power, jurisdiction, and right, which is not by this Constitution delegated to the Congress of the United States or to the departments of the federal government. And then in recommended amendment number 18 in North Carolina, this was one to prevent that kind of construction, expansive construction of federal power that would